Good morning, Philippines. Good morning, world. Good morning, real estate. My co-host graduated BS in Business Administration, major in management in Ramon Magsaysay Technological University. He first joined real estate in 2011 in Pragmatic Development and Construction Corporation and was its marketing manager. Today, he is the owner and founder of EMG Property Brokerage. He is a licensed broker, the president of Junior Chamber International, Olongapo chapter, and the current NREA Zambales chapter secretary. Welcome, Mr. Paul John Macadaan. PJ?
Thank you very much. Thank you very much, sir, and my co-host for today. He graduated with a BS Industrial Engineering degree at UP Diliman. He joined the Phil Estate Group of Companies in 1995 as an organization development specialist and a TQM trainer, where his eyes opened to the various opportunities of the real estate industry. 25 years after that, he is still actively involved as a PRC licensed real estate broker, appraiser, consultant, and accredited real estate lecturer, and BS REM instructor. He was the Secretary General, Treasurer, Vice Chairman of Education, Corporate Treasurer, Secretary General. For today, here is our current NREA VP for Internal Affairs, Mr. Jovi Tupas. Okay. Welcome to our NREA online business forum with the topic Prospects and Settlement of Conflicts in Housing.
Thank you very much. Thank you very much, PJ. So before we start, let us call on our NREA Iloilo chapter president, Ms. Annie B. Lencioco, to lead us in prayer.
Let us all put ourselves in the presence of our Lord. Almighty God, all praises to you before we start our activity today. Be with us, fill our hearts with joy, fill our minds with learnings. Thank you for the opportunity to meet together online. Help us come together to make NREA an institution that reflects your kingdom. Give us strength to continue working in this time of pandemic. Inspire our thoughts, discussions, and ideas, and continue to remind us all that what we do, what we accomplish, is for the greater pursuit of truth and glory of you. Amen. Good morning, everyone.
Okay, so let's proceed for the next speaker. To introduce our second speaker for today, he is the principal architect of RV Archiplus Design Studio, evaluator of CPD Council for Architecture of Professional Regulatory Commission, the chapter president of UAP QC Elliptical, the director for Committee on Continuing Professional Development, the administrative faculty of Enduran Colleges, and professional lecturer of National University. May I call in to introduce our speaker for today, Architect Ronnie Biando. Hello, Architect Ronnie. Okay, so since there is a technical difficulty on the side of Architect Ronnie Biando, let me introduce our speaker for today. He is presently the Commissioner of Human Settlements Adjudication Commission. He is presently the Supervising Commissioner of the Regional Adjudication Branches of Region 6, 7, 8, and 10, as well as the Chairman of the Human Resources Merit, Promotion, and Selection Board. He graduated with the degree of Bachelor of Science in Economics in Ateneo de Manila and earned his Bachelor of Laws, Juris Doctor in Xavier University Law School. Before being appointed as HSAC Commissioner, he was a former councilor and vice mayor of the local government unit of Tagoloan, Misamis Oriental. He was also a litigation lawyer, handling cases involving real estate, immigration, taxes, labor and banking, as well as an external counsel in Mindanao for the two top banks of the country. In 2016, he was a legal consultant of the Presidential Legislative Liaison Office of the Office of the President in Malacanang. Later, on July 2017, he was appointed as an Assistant Secretary of the Department of Justice handling security matters. As an Assistant Secretary, he was also the Chairman of the Department of Justice Housing Committee and the Department of Justice Action Center or DOJA. He was also an ex officio commissioner of the former Housing Land Use Regulatory Board or HLURB. And outside of his work, he is a husband and a father to four. And in his free time, he enjoys sports of swimming, biking, and running. Hey, let's greet everyone and welcome Atty Sergio Emano Yap II.
Good morning to everyone. Today I'll be discussing briefly the 2021 Rules of Procedure of the Human Settlement Adjudication Commission. So first of all, I would like to thank the NREA National President, Imelda Magtoto, as well as the Chairman of the Board of Trustees, Chairman Benigno T. Cabreto Jr. So I'll be presenting 52 slides. I hope this would fit my 20-minute time allocated for me. So as a background, the Housing and Land Use Regulatory Board, or the HLRB, has been reconstituted as Human Settlement Adjudication Commission, or HSAC, by virtue of Republic Act number 11201. As mentioned earlier by Ma'am Magtoto, HSAC is a quasi-judicial body tasked to adjudicate disputes relating to real estate developments, homeowners association, and appeals from decisions of local and regional planning and zoning bodies. In the performance of its functions, the HSAC is guided by the constitutional provision that affords all persons the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. HLRB's two other main functions, which were town planning assistance to LGUs and regulatory function over real estate developments and homeowners associations, are now exercised by the Department of Human Settlement and Urban Development, where the previous speaker, Yusek Sabili, is working. So the HSAC is attached to the DHSUD for policy planning and program coordination only. So I will discuss the next slide, which is the general flow of the adjudication process before our commission. So basically, it starts with the filing of verified complaint, and later on, the respondent will receive summons and a corresponding obligation to file an answer. So after the filing of the answer, there is the mandatory conference, wherein parties are given a chance to mediate amongst themselves, probably to arrive at an amicable settlement of the dispute. If there's no settlement, the parties will be required to file position papers as well as draft decisions. So after that, the adjudicator will have or issue their resolution or decision for the case. So the decision will be appealed later on to the commission in bank, or it can be to the division. Normally, it's appealed now to the division of the commission, and later on, under our new rules, which I will discuss later on, the parties, the aggrieved party may file a motion for reconsideration, and it will be resolved by the commission in bank. And all the decisions from the commission is appealable to the Court of Appeals via the Rule 43 of the Rules of Court. So I will now jump into this, the fifth slide, the jurisdiction and coverage of our commission. So first, we have jurisdiction over cases involving subdivisions, condominiums, memorial parks, and similar real estate developments. This includes, number one, actions concerning unsound real estate business practices filed by buyers or homeowners against the project owner or developer which cause prejudice to the buyers or which are committed with bad faith and in disregard of the buyer's right. Number two, claims for refund and other claims by a subdivision lot or condominium unit buyer against the project owner, developer, dealer, broker, or salesman, provided when the cause of action arises from the buyer's right under Section 23 of PD 957 and the purchase price of the property is paid through a housing loan from a bank or other financial institution, the latter shall be pleaded as a necessary party. So number three is cases involving specific performance of contractual and statutory obligation arising from the sale of lot or unit and the development of the subdivision or condominium project. Number four, disputes involving open spaces or common areas and their use filed by the project owner or developer or the duly registered homeowners association, including the eviction of illegal occupants therein. Number five is suits to declare subdivisions, condominium, or other real estate development within the regulatory jurisdiction of DHSUD as abandoned, as defined under Section 3 of RA 11201 for purpose of Section 35 of PD 957. Number six, disputes involving easements within or among subdivision projects. Number seven, actions to annul mortgages or other agreements executed in violation of Section 18 of PD 957 filed by the subdivision lot or condominium unit buyer against the project owner and or developer and the mortgagee. If you will, Section 18 of PD 957 involves mortgages, which says that no mortgage of any unit or lot shall be made by the owner or developer without prior written approval of the authority, now with the Department of Human Settlement and Urban Development, or DHSUD. So we will now proceed with the next slide. Our commission also has jurisdiction of involving homeowners association. So this includes controversies involving registration and regulation of HOAs, intra-association disputes or controversies arising of relations between and among members of HOAs, inter-association disputes or controversies arising of the relations between and among two or more HOAs, disputes between the HOA and the state, and disputes between the HOA and the beneficial users of its services. So we'll proceed to the next slide. The commission also has jurisdiction over disputes involving the implementation of Section 18 of RA 7279 or the Urban Development and Housing Act of 1992 as amended by RA 10884, which is the Balanced Housing Development Program Amendments, and its implementing rules and regulations. Next is the disputes or controversies involving laws and regulations being implemented by DHSUD, except those falling within the jurisdiction of other quasi-judicial body. And E, appeals from the decisions of local and regional planning and zoning bodies. And F is other analogous cases. So that is the broad coverage or jurisdiction of the Commission. So what is the nature of the proceedings of the HSAC? It's a quasi-judicial, as mentioned earlier. The HSAC's legal process is similar to quasi-judicial bodies such as the NLRC. This means that it does not involve a trial-type hearings like that observed by regular courts. Initial pleadings such as complaint and answer can be done using the complaint or answer form or template provided by the HSAC, either by accomplishing it manually or downloading the digital copy thereof and encoding the entries therein. It does not require engagement of a private counsel or lawyer, although it would be wise to have one. Private counsel or lawyer may be needed after the mandatory conference when parties are required to file a position paper as well as the draft decision. So we will proceed with the proceedings before the adjudicator. As mentioned earlier, this is the commencement of the action, as well by filing of a verified complaint and payment of the required legal fees. The service of summons to the respondent, together with a copy of the complaint and all its attachment. Next is the filing of the answer. Then the setting and the conduct of the mandatory conference, the submission of position paper and draft decision, writing of decision, and the issuance of the decision with notice to the parties. So the next slide shows the process flow within the regional arbitration branches of the HSAC, but I will not discuss that because this will be discussed in my succeeding slides. So I will jump to the slide 15 in regards to venue. A verified complaint is filed before the regional adjudication branch that has jurisdiction over the administrative region where the subject or condominium project is located. Exception, if the buyer resides in the same place where the principal office of the developer is located, the buyer may opt to file the case in the said region, even if the project is located in a different administrative region. So in terms of HOA cases, those cases are filed before the regional adjudication branch that corresponds to the DHSUD regional office where the HOA is registered or re-registered. So this is important. The next is the prohibited pleadings and motions. Often parties file these pleadings, and these are considered prohibited, and these pleadings or motions do not interrupt the running of the prescriptive period or shall not bar the adjudication of the case. This includes motion to dismiss, motion for bill of particulars, motion for relief from judgment, motion for reconsideration, except as provided under section 123 hereof of the rules, the appeal from interlocutory order or except writ of preliminary injunction, motion for extension of time. Most often, parties file motion for extension of time to file their pleading. This is prohibited. Motion for postponement, except for justifiable reasons. Motion to admit pleadings filed beyond the reglementary period. This is also prohibited. Fourth and subsequent party complaints. Motion for clarification of final orders and decisions. The manner of filing, normally pleadings are filed personally, registered mail, private courier, email or electronic mail, and other electronic means as may be authorized by the rules. But initiatory pleadings, take note that initiatory pleadings such as complaint, as well as initial responsive pleadings such as answer, shall be served only and filed personally or by registered mail. So the summary of that is that all complaints and answers should be filed either personally or registered mail. So for the issuance and service of summons, regional adjudicator to issue summons within 10 calendar days from the receipt of the case docket or within the same period to dismiss complaint motu proprio for lack of jurisdictions, fail to state a cause of action, or insufficiency in form and substance. Summons are served personally through the process server or sheriff or registered mail or private courier. Then the highlight of our rules, we added this: after at least 2 failed attempts of service of summons, the regional adjudicator may authorize the complainant to serve the summons to the respondents, provided the complainant executes an affidavit of service to be attached to the return of service of summons. Next slide is the filing of verified answer within a non-extendable period of 20 calendar days. The answer should be filed from the receipt of summons. All grounds for a motion to dismiss, counterclaim, or cost claim must be pleaded in the answer. Otherwise, they are deemed waived. And again, as there's an optional use of the answer form or template by the parties without counsel. Default, the regional adjudicator may motu proprio or upon motion to declare defendant in default if the party fails to file a responsive pleading within 20 calendar days from the receipt of summons, and direct the complainant to file within 10 calendar days his position paper, after which the case is deemed submitted for decision. There are also the right to file a motion to lift order of default, accompanied by affidavit of merit, which shall be filed within 5 calendar days from the receipt of the order or of default. Next is the mandatory conference. As mentioned earlier, this comes after the filing of the answer, and the mandatory conference, from the word, is mandatory. The notice for the conduct of the mandatory conference shall be issued within 5 calendar days from the receipt of the answer. It shall be 30 calendar days from the initial conference, unless the parties agree to an extension not exceeding 30 calendar days. No further extension is allowed. So what are included in the mandatory conference is the purpose of which is to consider the possibility of amicable settlement through mediation, as well as the agreement of the parties, to be served with subsequent pleadings, motion, and other documents, judgment, orders, or resolutions through electronic means. The agreement of the parties to conduct subsequent conferences, including mediations proceeding to teleconferencing, the scheduling by the regional adjudicator of the mediation, the definition and simplification of issues, possibility of entering into admissions or stipulation of facts, the submission by the parties of additional documentary evidence and marking of proceedings, which I mentioned earlier, which is part of the mandatory conference. It is mandatory. It is conducted within the period for the conduct of mandatory conference. All informations obtained during the mediation proceeding shall be confidential and shall not be admissible for any purpose in any proceeding, unless otherwise specifically provided by law. The appearance of parties in mediation proceedings is mandatory, or by the representative with the proper special power of attorney or secretary's certificate with full power to enter into a compromise agreement. Next is the filing of, if no settlement is arrived by the both parties, they will be directed to file position papers and draft resolution. So this is done within 15 calendar days from the receipt of order, and after which the case is deemed submitted for resolution or decision. The adjudicator may motu proprio or upon motion conduct an ocular inspection and or clarificatory hearing, which shall be conducted within the 90 calendar day period within which the adjudicator should resolve the case. So again, for the mandatory conference is 30 days plus another 30 days of extension, and after which the submission of the position paper and draft decisions. With the submission of that, the adjudicator has 90 days in which to resolve the case. Of the adjudicator. Consideration of the regional adjudicator's decision shall be allowed or acted upon, and the filing of the same shall not toll the reglementary period to file an appeal. So there is no motion for consideration before the regional adjudication branches. Next slide. The provisional and special remedies, the creation of management committee, the preliminary injunction, contempt, inspection of books and records, enforcement or execution of compromise executed by the parties in conciliation proceedings before the DHSUD, other provisional and special remedy. The executory nature of the judgment under provisional and special remedies. So all judgment under Part 3 of the rules of the HSAC shall be immediately executory without prejudice to filing of appeal therefrom, except for the judgment of the commission in bank indirect contempt cases which are unappealable. If you remember during the HLRB time, there is the cease and desist order. Presently, under the HSAC, under our new rules, there is the preliminary injunction. So there's no longer a cease and desist order, but now there's a preliminary injunction. So a preliminary injunction is issued to enjoin or restrain after due notice and hearing any actual or threatened commission of any or all prohibited or unlawful acts. While a preliminary mandatory injunction is issued to require the performance of a particular act and any dispute within the regional adjudication branches jurisdiction which, if not restrained or performed forthwith, as the case may be, may cause grave irreparable damage to any party or render ineffectual any decision of such event. So no preliminary injunctions shall be granted without hearing and prior notice to the parties sought to be enjoined. So next slide. The temporary restraining order. The elements thereof. If the matter is of extreme urgency, there is a showing that the applicant stands to suffer grave injustice or irreparable injury, it is filed before the matter can be heard on notice. So the period of this is only 72 hours from issuance, may be extended but not to exceed 20 calendar days. The party will be required to file a bond to be fixed by regional adjudicator, and the injunction or TRO shall be effective upon posting of the bond. So the conditions thereof, the provided notice of hearing is conducted. It should, as again, 72 hours. Whom the case is pending shall conduct a summary hearing to determine whether a TRO shall be extended until the application for preliminary injunction can be heard. As mentioned earlier, it should not exceed 20 calendar days, including the original 72 hours provided therein. So in the event the application of preliminary injunction is denied or not resolved within the said period, the TRO is deemed automatically vacated. So next slide is the motion for dissolution of injunction or TRO. So a motion for dissolution shall be filed join within 15. The adversary may file a comment within a non-extendable period of 5 days from the receipt of the motion. After receipt of the comment or lapse of the period to file the same, the regional adjudicator shall resolve the motion within 5 calendar days therefrom. If granted, movant to post a bond in an amount twice that posted in the issuance of injunction or temporary restraining order. So, petition for review of writ of preliminary injunction. A resolution granting or denying a motion for dissolution of writ of preliminary injunction is appealable via a petition for review to the Commission in bank within 15 calendar days from the receipt of a copy of the resolution. So, this is the next slide is the sample. Often there's a mistake as to the this is the sample which I encourage the lawyers to follow. In the RAB level, this is the case caption, but on appeal of the petition for review of the injunction order, in case of a developer, as the petitioner, it should be against the adjudicator as a public respondent and the complainant as the private respondent. So we'll now proceed to the next slide, contempt. As you all know, under the new law, HSAC has a contempt powers. So we have the power to issue a direct contempt. So as indicated here, a person who commits any act of misbehavior in the presence or so near any member of the commission or any of its regional adjudicators as to obstruct or interrupt the proceedings before the same, including disrespect towards said officers, offensive acts towards others, refusal to be sworn or answer as a witness or to subscribe an affidavit or deposition when lawfully required to do so, and other such analogous acts or misbehavior disruptive of the proceedings. This includes disrespect towards our sheriffs. So next slide. Can we proceed to the indirect contempt? Indirect contempt includes disobedience or resistance to lawful writ or order or judgment of the HSAC, any abuse or unlawful interference within the processes or proceedings of the HSAC not constituting direct contempt, any improper conduct tending or directly or indirectly to impede, obstruct, or degrade the administration of justice, representing himself or herself to be an attorney or officer of the HSAC and acting as such without authority, failure to obey a subpoena, duly served, and recovery or attempting to recover without any authority, a person or property being held in the custody of an officer by virtue of an order or process issued by the regional adjudicator or the commission. So, review of the judgment or final order of indirect contempt may be appealed to the commission. So, next slide is the enforcement of or execution of compromise agreement executed by the parties in conciliation proceedings before the DHSUD. The petition for the enforcement or execution of a compromise agreement between parties as an outcome of conciliation proceedings conducted by the DHSUD acting on letters of complaint or request for assistance in relation to its regulatory mandates over real estate development and homeowners association. The compromise agreement should not be contrary to law, morals, or public policy, and the respondent failed to comply with the terms and conditions of the compromise agreements. This, as mentioned earlier, there's still a conciliation proceedings before the DHSUD right now, and any compromise agreement between the parties can be enforced or executed through filing of a petition with the with the HSAC. So now I will proceed with the proceedings before the commission. So I will not discuss the flow chart because I will be discussing it through the succeeding slides. So again, the commission is composed of 5 commissioners appointed by the president. Right now, there are only 3 commissioners headed by Executive Commissioner Melzar Galicia and Commissioner Fidel Esconde. So the commission sitting in bank shall resolve the following: petitions for review of writ of preliminary injunction, appeals from decisions of local and regional planning and zoning bodies, cases involving novel issues with policy implications upon endorsement of the division to which the cases were originally raffled, appeals from the judgment or orders in election contests, motion for reconsideration of judgment or orders rendered or issued by any of its division under section 123 of the rules of procedure. So next, in order to efficiently carry out its adjudicatory function, the commission may also sit in 3 divisions, each composed of a combination of 3 commissioners, provided that no two divisions shall be composed of the same commissioners. So right now, there's only 1 division composed by, headed by the chairman of the first division, the Executive Commissioner Galicia, as well as members thereof are Commissioner Fidel Esconde and myself. So all other appeals shall be resolved by the divisions. So no motion to inhibit the entire division or the commission in bank shall be entertained. So next slide, appeal from the judgment of the regional adjudicator. This is the process. When you are, the aggrieved party may file an appeal memorandum and payment of appeal fee by filing with the regional adjudication branch a verified appeal memorandum in 3 copies within 15 calendar days from the receipt of the assailed decision of the adjudicator. So within 5 calendar days from the receipt of the appeal memorandum, the RAB shall elevate the records of the case to the commission together with the summary of the proceedings. So I highlighted this, the appeal bond, because there are so many cases right now wherein parties, the aggrieved parties, file appeal without filing or payment of the appeal bond. So under our section 110 of our rules of procedure, in case of money judgment, an appeal bond in cash or manager's check posted with the commission or surety bond equivalent to the amount of the award and actual damages excluding interest and other damages and attorney's fees. Then after receipt of the appellant's memorandum and without waiting for a separate order from the commission, the appealee shall file a counter memorandum directly to the commission through the office of the executive clerk of the commission in 3 copies within a non-extendable period of 10 calendar days from the receipt of appellant's memorandum with proof of service to the appellant. Appeal from the decision of local and regional planning and zoning bodies. A party aggrieved by the decision of any local or regional planning and zoning body may appeal therefrom any legal ground to the commission in bank by filing with the office of executive clerk of the commission a verified appeal memorandum with a copy of the relevant zoning ordinance and or other supporting documents in 3 copies and payment of the appeal fee. The appeal shall be made within the period provided in the zoning ordinance of the city or municipality. In the absence thereof of such ordinance, the appeal should be taken within 15 calendar days from the appellant's receipt of the decision of the local or regional planning and zoning body. So the commission may, in the evaluation of the appeal, order the reception of evidence, order the conduct of clarificatory hearings or ocular inspection, or issue subpoena when necessary. So next slide is the judgment of the commission. So when is the appeal deemed submitted for decision? So it is upon the filing by the appealee, or in the case of several appealees, the last appealee of the counter memorandum, or when the period to file the same expires. So upon the receipt of the last counter memorandum, the case is deemed submitted for the decision of the commission. So then the commission in bank or its division shall resolve the appeal within 120 calendar days from the date the appeal is deemed submitted for decision. So next slide, the notice of judgment, notice of the resolution of the appeal by of the judge, parties and their counsel not represented by counsel. When a party is represented personally by counsel personally, or that contains a copy of the judgment ahead of such parties, the judgment appeals will be reckoned therefrom. So motion for reconsideration of judgment or order of the division. It should be, I mentioned this earlier, the decision of the adjudicator is not appealable by filing of a motion for reconsideration, but the decision of the division of the commission upon appeal, the party is now allowed to file a motion for reconsideration within the 15 calendar days within which to appeal the said decision. So it will be filed before the commission in bank, and only one motion, such motion for reconsideration, shall be entertained, and the commission in bank shall resolve the motion for reconsideration within 30 calendar days from the date the motion is deemed submitted for resolution. So maybe the next question will be, after the MR, the resolution of the MR, where can the party file the appeal? So as mentioned here, the party can appeal within 15 calendar days to the Court of Appeals under Rule 43 of the Rules of Court. So next slide. The finality of judgment. After the lapse of the 15 calendar days from the date of receipt of the judgment or final order and no appeal has been perfected, that is considered the finality of judgment. So the date when the judgment or final order becomes executory shall be deemed the date of its entry. So the decision will later on be entered into the books of the commission and shall forthwith be entered by the executive clerk or his representative in the book of entries of the commission. So now we proceed with the execution of the final decision or judgment. Execution shall issue motu proprio or motion by any interested party upon a judgment or order that has become final and executory. So without need of a separate order from the regional adjudicator, the adverse party may file an opposition to the motion for execution within 5 calendar days from the receipt of the motion. So the regional adjudicator shall resolve the motion and issue the writ of execution within 15 calendar days from receipt of the opposition or lapse of the period to file the same. And no opposition has been filed. Unless the regional adjudicator determines the necessity of a hearing, in which case the regional adjudicator shall issue an order resolving the incident within 15 calendar days from the hearing. So as to the writ of execution, this is very important. All the writs of execution shall be issued by a regional adjudicator directed to the sheriff concerned. The Commission may issue rates of execution to implement and enforce its judgment on direct contempt when committed against it or any of its members, directed to the executive clerk as ex officio sheriff or any deputy sheriff. The Commission may also designate special sheriffs and take any measure under existing laws to ensure compliance with its decision, orders, and words. So, again, this is next slide, please. And the resolution for the motion for execution. So I would like to remind parties in relation to this section. So again, writ of execution is not appealable. All incidents pertaining to the execution of the final executory judgment shall be resolved by the regional adjudicator or the commission as the case may be, and where necessary, a special order for execution of the judgment or order or award shall be issued. So my last slide in relation to the effectivity of our rules. It shall take effect 15 calendar days after their publication in the official gazette or in a newspaper of general circulation. The rules were published last March 6, 2021 in the Philippine Star and became effective last March 21 of 2021. So that will be all for my presentation, and later on I'll be open for questions during the open forum.